Muhammad on behalf of the people, P86771.
No, it's not. You have work. So
Yeah,
you're on fire.
Are you please sit at the desk representing yourself?
Judge needs to address you, sir. Is that a problem, sir?
Yeah. You're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
Maybe I'm not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to...
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has...
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on, are you picking him up? That's one of the reasons I want you up here, is there's a microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have...
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
May
All right, so that's a no. You don't want him to represent you?
No, he's, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, you know, pending Your Honor's ruling on that jurisdictional issue, I have prepared for to conduct a preliminary exam.
Okay.
And could be, you know, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record. I'm fine.
Okay.
So with that being said.
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So today,
you have a jurisdictional argument you want to make?
Well, I've served notice.
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
yes or no.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional
argument? I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of Michigan?
District courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is it?
And it's not common law. It's statutory.
Okay, so it's statutory. That is what? Civil?
No.
So what is it? For the
My
record, I need to
jurisdiction
have
is
that on-
both civil-
I can't defend myself unless I have it on the record. Is it,
My
it's
jurisdiction.
only two?
Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right, so is that common law or average?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes,
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
there must be what?
An injured party.
Yeah, it's the
A
people of the
corpus
state of
delicti.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed, all
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I
are
injure the
bringing the
state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I understand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one. All
I see.
right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the
So-
OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name.
You're a witness. Yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a
I
question.
object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people call Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
my objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause. I just.
This is a problem. This is a preliminary exam.
This is, okay, so right here. it
This is
says-
the probable cause hearing.
It says, it's.
All right,
it
stop,
says-
stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal
I
objection
also-
is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied not?
Because
have
you
my due
didn't give me a
process?
valid objection.
I object.
You can't just object. You got to explain with the valid
I
objections to the
object
evidence.
that we are having a preliminary exam when I haven't had a probable cause hearing that I did not.
They're the same thing,
It's
Mr. Michaud.
still, on this. it
Mr.
doesn't-
Michaud,
it
they're the
doesn't-
same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. and today is a different date that says a preliminary.
Have you ever had a grilled
If it
cheese?
was different,
Have you ever had a grilled cheese?
if it was different, why would it have two
Have you
separate
ever had a
columns?
grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I mean, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
Understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it? Because if it's a hearing, or
You
a conference,
didn't
right,
waive it.
so
There's nothing to
do
hold.
I have a right to have a probable cause conference?
No,
What?
you can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There-
And in order
There's no
to prepare,
preparing for a probable cause
It's-
conference.
it's-
It's a conversation.
it still takes preparation.
You want a PCC? Go out in the hallway, have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to—
He can appeal them.
as you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, the waiver does not preclude him from
Not at all.
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to that burden, he also maintains the right to, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As
with
far as
counsel.
I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I want like to.
First
address my
notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal
the
what?
bid
Hold
bond.
on.
I
What?
requested the bid bond, the performance bond. I have an affidavit.
There
and
is
I
no
did-
bond.
There are bonds. This is
Okay,
you said it's criminal.
listen. You can't tell me something and then just disagree with me
Well,
and think.
okay.
Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay, that's just the way it works. My courtroom, I get to decide how it's run. There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone
I
here
don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address, okay, so.
I'm not addressing any of that crap you
Can
got in
you-
front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have
It's on the record. Order a transcript. I'm not signing anything for you.
okay. Also, I want to also address that. I sent a affidavit of fee schedule for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice and.
Great.
you haven't-
Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you
Okay.
said that.
Right, and
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am not
recognize
a
any of
United
that.
States citizen. I am
Stop.
actually
Hold on.
identified.
Stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't
Under
recognize
what-
that.
Under what law could you represent or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does
Can you
mean, hold
prove
on. It should mean something
Can you
because,
prove it? Please prove it.
can I prove what?
Prove that I am not that I am the artificial person. Period.
I can prove you're Frank
I have
Michaud.
full faith and credit.
I can
I
prove,
have, okay, so.
hold on, you've
Are
asked
you-
me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And I
You
actually
proved
told
it
you
for
threatened
me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing. But
Okay?
you're still threatening me and you're using it under color of law.
Okay, listen,
And plus you
listen to
have-
me. Mr.
you
Michaud,
have- You have.
I've
multiple
wasted
officers.
too much time with you. Yes or
Okay.
no?
So,
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or
I
no?
object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
I object to that. That's.
I'm happy to hear your objection.
Due process.
Appeal me. That's why circuit court judges have jobs.
Definitely.
Take him out of here.
Under color of law.
I can give you more than 30 days. John, ask the wife to come in so he can see his property go to his wife. Ma'am, would you accept some personal property from your husband, please?
That was an extreme amount of patience.
Good try.
I appreciate you, giving him as much latitude as you did.
I just can't let him run things. I'll let him engage me and, I don't mind that, but I just can't let him try to run things.
Yeah. no,
Especially when I got 3 or 4 more exams to do.
Right.
The internet is the worst thing in the world for these guys.
I tried to tell him,
It don't play
the
here.
court is going to deny your objection. Let's allow this to move forward. He might have been able to win this.
And that's the
case.
worst part about all these
Yeah.
cases, right?
Yeah.
Because sometimes they've got a chance if they just,
We had a good.
Ron
argument, argument.
White, right?
Yeah.
Got a constitutional right to remain silent, just can't do it. You got a motion filed?
Yeah, oh, yes, absolutely. She had, I actually had issues to discuss before I crossed.
But the court reporter needs to pick you up.
Here, you don't have to be at the podium, but at least have a seat at that table where that microphone is.
Threats, coercion, and I'm under duress. I'll cross.
You're under duress. How are you under duress?
Well, Your Honor, as stated in my motion, there's actually fraudulent word that since unsigned by a judge. I have lawsuits filed on all of this stuff right now, which I know that they received.
Hold on, brother. Wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand that. I'll do it. Okay. The front check or something.
That's fine, just make sure you're talking to the microphone.
Absolutely.
Okay. All right, you can sit down. Okay. So I think this is your motion to dismiss, right?
Yeah, I have a few in there that I've been repeatedly trying
Okay,
to
well,
be
which one do you
dismissed.
want to start with first?
Well, the recent one I filed, the motion to reject the swearing in and all that based off the fact that, like I said, I was sent a default motion that, I don't know how it even got sent out past the day, but it was never signed or anything. I was also defaulted out the fact that there was a citation that never even presented a court appearance.
Okay, hold
date
on.
and
You're
all
giving me
that
too
stuff.
many issues. You're talking about swearing in, you're talking about a default judgment. Just pick one issue. We're gonna deal with them one at a time. So what do you want to deal with first? You want to
Well,
deal
my
with the
main motion.
default?
Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, don't suppose, it's your motion, brother. Tell me what it is.
Well, it keeps getting
I mean,
set
that's the only
aside, so
civil
I
infraction.
have numerous, I
Hold
have lots of stuff.
Hold on,
going
that's the only civil infraction I see with your name on it. So I'm just confirming that we're talking
Yes,
about
it was over
that
the-
charge.
Yeah, sure. It was over
Okay. So do you know why the default was entered? Did you miss a deadline? Did you
Well,
not?
I was notified, I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled, but I went back looking at the citation, there was no date, and actually how fast it got issued raises real concerns to me. And then once I received the default in
Okay,
the
hold
order.
on, hold on. Let's take one thing at a time. So you said you never got an appearance date.
Correct.
Do you have a copy of the ticket? Because I've got a
Yeah,
copy.
I
of the
said
ticket.
it's in there, it's attached to my motions.
Okay, do you have a copy of
Yes,
the ticket?
I do.
Okay, then I'm gonna ask you to look at that copy of the ticket. Because my copy of your ticket says contact court for appearance date.
It says contact court for appearance date, where it says appearance date on or before, there's nothing.
Okay,
They
but
didn't
it
give me no
says,
time frame.
it says contact court for appearance date. That
How
means the
long?
monkey's on your back to contact us.
I will also on the bottom of the tickets, it says, if you fail to contact court within the specified amount of time, there was no specified amount of time on here. I had no idea when I was supposed to contact court. I was dealing with trying to get my
Well, let me
attorneys.
ask you this. Did you contact the court?
I was again, as I said, I had no sort of any time frame
Mr.
to
Crucell,
contact the
Mr.
court.
Crucell, this is gonna go a lot easier on everybody if you just answer the question I asked. I'm gonna give you plenty of chance to give me any argument you want to give. Okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm gonna take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that actually when I was defaulted, Your Honor.
Less than that from what?
From whatever this was issued. And like I said, I was contacting.
Well, once
attorneys.
again, I'm gonna draw your attention to the ticket. My ticket, which I think is the same one you got, is dated February 3rd.
Correct.
Okay, so that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of a default?
Actually, I know I got the thing in the mail. When did I get this? This says that. I don't think it specifies a date.
Well, did you make a note when you received it?
This said I don't remember exactly what date I received this in the
Okay.
mail, but this was scheduled for March 8th.
Okay.
So that was even less than.
But what is that that's scheduled?
This says it was for my order, the motion affidavit saying that I was defaulted and saying that I needed to pay bond and then a warrant would be issued. And I said,
Okay.
again, that was never.
And that's dated what?
This was dated 3/8. That I needed to appear
Okay.
on or before 3/8.
Okay, so that was March 8th. You were defaulted February 22nd.
Okay. Which then, again, there was no dates. I had nothing. I had no
Okay.
notice
Well,
of any
well,
sort of.
well, once again,
appearance.
you're not hearing what I'm telling you. The monkey was on your back. The ticket clearly said you contact us. You never did.
And it also specifies right here, if you fail to appear by the date specified And then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay,
There was no dates.
okay. Do you have anything to add?
I do, Your Honor.
Go ahead.
Mr. Crusoe brought this up when we were in front of the Honorable Judge Martin. She did set aside the default of a civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir,
aside.
do not interrupt the lady. Did she interrupt you?
No,
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Crusoe did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because Judge Martin set it aside.
So the default's already been set aside.
Yes,
Brother, why'd you just waste 5 minutes of my life?
since March 14th, Your Honor.
which I object to that because they.
You object to your motion being
No, I
granted?
object to them setting aside my motion. And I
No,
object
no,
to
no,
this.
no, no, wait, listen. She tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of that.
So you want to argue about the fact that you got what you asked for?
No, what I'm saying is the fact that the due process was violated is what happened in this whole problem. When I was defaulted, due process was violated.
So what? She set it aside.
Not, listen, okay, it was set aside to cause damages to me because of what happened with the default.
Well, explain to me how you were damaged.
First off, there's threats made against me, right? Clearly he's threatening me to
No,
issue
no, no.
warrants,
I didn't ask you
threatening to
about
pay
threats.
money.
I said, how were you? You said you were damaged. I'm asking you, what was the damage?
But the fact that I was threatened to come in and pay money or warrants. would
How
be
was that
issued for my
damage?
arrest. And I was being threatened by Huron Police, which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money or I would have been, they'd have been issued.
What money
warrants.
did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside. And Judge Green never said a word to
Stop.
me about any of that.
It's been set aside. Counsel just said, Judge Martin set aside the default. So what that means is procedurally, it's like it's a brand new file. Understood?
Yeah, but that's according, yeah, but that, especially now with the new Chevron overlay, that's just saying that she's just trying to set it aside, that there's no issues. with
She
the
didn't try to
court.
set it aside, she sat it
But she
aside.
can't. She can't just set my rights aside.
She's not setting your rights aside, she set a default aside because you asked her to.
Well, so if it's set aside, then the money should be returned, correct?
Well, I don't know, did she address the money?
I don't
No,
think
she
so.
never did. No one did. I
Sir.
explained in my motions.
Sir, I'm gonna hold you in contempt the next time you cut her off. The first contempt, $100. The second contempt, a day in jail. Are we clear on the ground rules for my courtroom? Is that a yes for the
Yes, Your
record?
Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay, I understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm, the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right? So we started with, what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. So that motion's done. Would you agree?
As long as my money gets returned, then I guess it's taken
At
care
some
of.
point, trust me, your money will either get applied or returned. Next motion you want to talk about.
The dismissal based off the fundamental violations of my fundamental rights and due process.
Okay, well, tell me more. Do
Okay.
you have, hold on, let me just cut to the chase. Do you have more than just the fact that you think you have a right to travel?
Yes, Your Honor. Actually,
That's denied. I'll just cut to the chase. That's denied. I don't buy into that argument. Now, you can appeal that decision to the circuit court. You understand how that works? District court decisions, you can appeal.
absolutely.
Okay, hold on. I've denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying, I object to the
You
denying.
can't
of my motion.
object. You can appeal.
But I'm just
Okay.
letting you know, I'm stating for the record that I am objecting to your denial of my appeal.
That's fine.
Okay.
Circuit court judges have bills to pay too, right? So you appeal me to the circuit court. Do you have any other argument why these cases should be dismissed?
Yes, absolutely. Well, honestly, Your Honor, like I said, I even have both lawsuits. They've received my lawsuits to the Huron Township Police Department overall.
Hold on. I don't know anything about lawsuit. How would you suing the township work as a reason to dismiss these charges?
Because the initial traffic stop and everything was an unlawful stop from the get. I was
Okay, but that's got
retaliating.
nothing to do with your lawsuit. That might be the basis of your lawsuit. So you want to talk about whether or not there was a valid reason for a
Yeah,
stop?
absolutely.
Then make the argument.
Yeah, Your Honor, so prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that are friends, and actually two that are currently working within Huron that had confirmed I had every lawful right to be doing what I was doing. The one even pulled up to me and my wife at a gas station in town, and we are in Sibley and Middlebelt, right near actually where I got pulled over. And we had discussed it and talked about it and went on about our day. And this was all prior to this incident. I had two other interactions with this officer where I had specifically told him, I've already been confirmed and doing lawful, I'm well within my lawful rights. I have it documented. You need to go talk to the sergeant that I've been talking to and a couple other buddies, right? I gave him that opportunity. It was shortly after that. And I had that confirmation well prior to me even being pulled over. Okay. So then, this officer seen me leaving my house, pulling off my dead end dirt road, proceeded. Like I said, I even told him, I've already had this, I've already addressed this. You need to go talk to the sergeant.
Right.
Chose not to. Pulled me over, walked up, just started demanding ID and everything from me. He wouldn't identify himself, none of that good stuff. And then now this is where it's all led to. And I informed him, I have body cams, I have my own recording. And like I said, I have a lot.
Okay, but you started out by saying you wanted this dismissed because there was not probable cause for the stop.
Correct.
Okay. And then you went on to tell me how there was obviously a difference in opinion within the department about whether or not what you were doing was legal or not.
Well, I
is that a fair summation?
What was that?
Is that a fair summation of what you just said? Some of the officers that you talked to said you could do that, and obviously the officer that wrote you the ticket didn't think you could.
Correct.
Okay, so that's a difference of opinion there, which has very little, if anything, to do with the probable cause for the stop. So I'm going to let the prosecutor explain her position on probable cause.
That's it.
Go ahead.
Thank you, Your Honor. Defendant is requesting this court dismiss the case because of the accusation that operating an ORV on the roadway constitutes a blatant violation of his First Amendment rights and an improper attempt to regulate his constitutional rights. In his most recent motion, he does accurately cite Terry v. Ohio as controlling. This was plainly a Terry stop.
Well, hold on. His argument is there was no reason for the stop.
He does cite Terry v. Ohio in his newest motion.
Okay.
Because people submit that the investigatory stop exception in Terry v. Ohio controls the validity of the traffic stop. An officer may stop and briefly detain a person on the basis of a reasonable suspicion that criminal activity is afoot. Defendant claims that he was stopped without legal justification. Rather, defendant was stopped for operating an ORV on the roadway in violation of MCL 324.81122 as adopted by Huron Township ordinance. Pursuant to the United States v. Ferguson, so long as the officer has probable cause to believe that a traffic violation has occurred or was occurring, the resulting stop is not unlawful and does not violate the Fourth Amendment. On authority of state law and township ordinance, a person shall not operate an ORV which is not registered upon a public highway, street, or right of way. On the date and time of the offense, the defendant operated an ORV which was not registered, specifically an ATV on Middlebelt Road, a public highway in Huron Township. Additionally, during the course of the investigatory stop, defendant failed to provide a valid driver's license and failed to immediately disclose that he was a valid CPL holder and carrying a firearm, which is why he was cited.
All right.
Which I object to the.
Hold on. All right, so the one misdemeanor is operate the ORV on the roadway, and the other one is fail to display a valid license. Okay, all right. So that's her response to your argument. They didn't have probable cause. What's your reply to her response?
Well, I object to her terms of operate. There's no evidence that I was operating anything.
Okay, let me stop you. I killed that when I said the whole traveling thing doesn't go anywhere with me. Operating and traveling, as you define operating, or as you define traveling, we define it operating. So hold on, I've already ruled on that issue. You can appeal that decision to the circuit court. We're not going to plow that field again. So now we're talking about probable cause. What I just heard was the township has an ordinance that says nobody can operate an ORV on a roadway. Would you agree that's an ordinance in the township?
Your Honor, I may agree.
Yes or no? Mr.
Yes, I agree with that.
Okay, stop. If that's a valid argument or ordinance, and when I say valid, I don't mean if it's constitutional, if it's, stood the test of a challenge. I mean, if it's on the books, all right? If it's a valid ordinance and the officer sees you doing what that ordinance says you can't do, and he pulls you over, that's plenty of probable cause for the stop. So your motion to dismiss for lack of probable cause is also denied. Do you need me to clarify that ruling for your appeal reasons?
Yes, yes, actually, because Your Honor, I object to
What
the
do
fact
you
that
not
it's calling it
understand?
an
Sir,
ORV.
your objections mean shit to me, okay? I don't care what you're objecting to. I don't expect people to like every decision I make. That's why there's an appellate process. So you keep saying, I object, I object, I object. I don't care, all right? It's not helpful for today's process. My decision to deny your motion to dismiss based on lack of probable cause is because there was probable cause, because there was a clear ordinance on the books that the officer thought you were violating. That gives the officer a reason to stop you. Do you have any other reasons why you think these matters should be dismissed today?
Yes, absolutely. First off, they're trying to label what my private property is an ORV. It was not an ORV, and it's not even technically an ORV. If you look up the definition of ORV, it is not an ORV. If you look up the definition of automobile or vehicle or any of that sense, that's what it falls under. It does not fall under an ORV. They're just trying to label it as an ORV is what is happening.
Okay. That seems like that would be an issue for trial for you to testify, maybe me to see some photographs, maybe the officer to testify, and then I'll decide whether or not it meets the definitions of the statutes. Would you agree with me? Because that seems like a triable issue.
I suppose, yes.
Okay, well, this isn't the trial.
Well, I understand
I don't think
that.
it's scheduled for trial. Right, this is just motion. All right. Any other issues that you want to hang your hat on as why it should be dismissed? It being these files.
Like I said, from the beginning, it was like the officer had already been notified 2 times prior to this that what I was doing was lawful, that what I was doing was not an ORV, which I had stated to him.
But that's
He's witness to that as
Mr.
well.
Purcell, with respect, that's all your opinion. Obviously, the officer had a different opinion about all those things.
Well,
Right?
the officer chose to retaliate against me is what happened, Your Honor. Which I have the evidence and I have witnesses going on.
Or he had a difference of opinion about whether or not you were driving an ORV.
Or just didn't understand the laws. Or
That
the
could be
actual
too.
wording.
That could be too. But guess who gets to make those decisions at trial?
Well, honestly, in the trial, I'd request a jury trial, which is guaranteed.
Well, you can't get a jury trial on the civil infraction, but you can certainly get a jury trial on the misdemeanors.
Absolutely.
Okay. Do you have anything else to be discussed today on motion day?
Well, yeah, and as far as the disclosed CPL, like I said, I have, again, stating I have the body cams and I have my own
But
recording.
sir, stop. That's going to be an issue at your formal hearing, whether or not you violated that civil infraction. Once again, I got to have evidence, right? I got to take testimony. I'm going to hear from you. I'm going to hear from the officer that wrote the ticket. And then I'm going to decide at formal hearing whether or not what you did was reasonable or not reasonable. But today's just motion day. Today's not the trial. No testimony is being taken.
Oh, I understand that.
Okay. Anything else today?
Well, I guess that's no, but like I said, again, for the record, I do object to moving forward. I do object to anything moving forward from this point.
File your appeal.
No, that's fine. I will.
File your appeal.
I'm going to. That's fine.
Okay. All right. Now, the 200, let's get back to the $280. We'll talk about a jury trial date. Are you going to represent yourself at a jury trial?
Yes, Your Honor.
Good luck. All right. Now, Mr. Purcell, I'm going to strongly suggest that you get an attorney involved in this. And we've got court-appointed attorneys that will be happy to talk to you from this standpoint. I'm not taking you to law school on the jury trial day. I'm going to assume and treat you accordingly that you know the rules of the game.
I understand, Your Honor.
You don't.
Oh,
You might say that. You don't understand the rules.
I do.
Okay? How many jury trials have you had?
none, but I have all the evidence.
How many jury trials have you had?
Your Honor, none, but I have all the evidence.
The evidence isn't the rules. There are a lot of procedural rules that will trip you up if you don't know what you're up against, and you don't. I'm going to suggest to you that even if you want to handle your evidence presentation yourself, you might want to get an attorney involved to help you with the procedural rules, because once again, I'm not going to take you to law school that day. I'm not going to subject the jury to that. It would be a waste of their time. You understand that? All right. Now, and I'm not trying to talk you out of a jury trial. Believe it or not, I'm trying to save you from yourself right now. If you want to have a bench trial, I will be much more lenient with you not knowing what you're doing procedurally, because then it's just our time. But when it's a jury in here, I'm going to run the most efficient jury trial I can. And that means I'm going to treat you like you're an experienced lawyer and know all the rules.
Okay.
All right.
All right.
So if you decide, number one, that you don't want a jury trial, you want to do a bench trial, let me know long in advance of that date so we can save it for somebody else. Or two, if you want the assistance of an attorney, I will give you the ability to talk to one of our court-appointed attorneys and see if they can assist you in the manner you want to be assisted.
Okay.
Understood?
Yes, Your Honor.
Any questions?
Nope.
Anything else?
Not yet.
Have a nice day.
Thank you.
Royce, I was trying to get you some work earlier.
Oh, I almost ran out of the courtroom as soon as you said, oh, I'm happy to assign someone. You would have seen like the cartoons, like me going through the wall, and just like impermanently going through it.
But these guys kill me.
I never
If-
about the travel, like time traveler or whatever. I never
The last few sovereigns I've had in front of me, honestly, they had decent legal arguments. They just don't know how to get them out,
Right.
The
one that I think.
Not that the traveling's a good argument.
I heard half of it.
Yeah.
You said like whatever he was driving under the definition wasn't like an ATV.
So that might be a good
That might
argument.
be-
Yeah, there's a lot of stuff out there that's like hybrid stuff that
Right.
since all those ordinances and statutes were written, so there could be something that falls through the cracks.
Yeah, absolutely.
But he's not gonna get anywhere with his vitriol.
No, what is this weird thing? What is the trap? I don't understand that.
It goes way back when we traveled,
I know this.
without machines.
We have a constitutional right to travel. Is it some kind of like?
That's what they're using. They're saying I've got a constitutional right to travel and you can't restrict my right to travel by making me have a driver's license.
Okay.
And honestly, my memory stinks, but one of the first things I remember learning in driver's education was like day one, driving is a privilege granted by the state of Michigan. It's not a right.
Right.
We'll take that privilege away if you break the rules.
It seems like pretty,
Yeah. Well, and that's what I try to shut them off. It's like, look, I don't buy that argument. I'm going to deny your argument, but go ahead, appeal me.
Right.
If you really think you're on solid footing legally, go appeal me. Circuit court judge can tell me I'm wrong, which ain't going to happen because those arguments have been tried repeatedly. All right, appearances for the township. Have a seat, make yourself comfortable. All right, so Mr. Crucell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to be addressed immediately, especially with the additional violence and the process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed,
Is that a yes or no, Mr. Crucell?
it's covering all the additional violence.
Okay, listen to my question. Is it any different than the last motion to stay proceedings you filed? Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
I just have the same issue to me telling you didn't give a shit about what I had to say.
Okay, hold on. Listen, Mr. Crucell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers Judge Green telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have been stopped a while ago. It's just-
That's not the way it works. Mr. Crucell, hold on. Okay, that's the last time you're going to interrupt me today without a contempt of court charge. Is that clear?
Your Honor.
Is that clear?
Constitution against me this entire time. No one has made her answer that.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept?
You're supposed to be impartial.
I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
So it means you, if you're agreeing with that, definitely means that you guys are lying against us.
So that means in any case, when I buy the arguments from one side, that means I'm colluding against the other.
You're agreeing.
Yes or no, Mr. Crucell? No, you have to answer my question. Contempt number one, $100. Answer my question. Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? $200. Yes or no? Because I can do this all damn day. And when I get tired of this game, then I tell them to put you in custody because it's contempt of court, criminal contempt in my view.
Yes.
It is. All right. So now, any argument you make from there, I'm going to deny because that's an unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making.
What statement is that?
It was
I thought we were talking about Judge Green's SOS statement.
when you made the statement that you were setting aside my regular trial, saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting it outside, not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my point and setting it aside. That's what you were doing.
Mr. Crucell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just get disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself. If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
Dog and pony show. This court has failed to let me make any of my statements, any of my cases. You even were trying to threaten me with contempt. Anytime I tried.
I am threatening you with contempt.
My objections on the record, you make my case. So here's
No, because third contempt. Do not interrupt me. When I said your objections don't mean shit to me is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence. And you say, I object, Judge. She hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. That's a proper legal objection. When I rule in her favor and you say I object and I say, what's your objection? And you just disagree with me, that's not a legal objection. That's why I said your objections mean shit to me because you're not using the word appropriately. Because you don't know what you're doing. That's what I tried to tell you originally the first time you were here. You've never been to law school. You've never tried a case. You don't know the rules of evidence and all the other things that have to be in play to have a trial go forward appropriately, properly, and to be perfectly honest, in your best interest.
And Your Honor, again, you're trying to spin this here.
I'm not spinning.
My objection is based on you not allowing me to do it. And that's when you told me my objection to be.
Okay. All right. So let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
Especially with the jurisdiction, she's never once it's on the why is it on the prosecutor to prove those things? There's false words and irregularities.
All right, let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking place now shows exactly that there is enough to show. You're supposed you need to.
Once again, you're not answering the question I asked. You just said you will not participate, and I asked, what do you mean by that? I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
And go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if you accept the motion and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me getting all my instructions.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
Statement I'd like to put on record that if whatever you would like to do from there, you can, because I open until these things. Like I say,
Hold on. Is this statement preceding all these motions you filed? Okay, then let me make my ruling on all of them. I think there's a motion to dismiss for lack of jurisdiction, correct? Okay, would you like to respond to that one? Because I think that's already been addressed.
Please arrested Mr. Crusoe while he was in Huron Township, but before district court has jurisdiction over offenses that occur within the township, both civil and criminal. This is criminal and civil.
Did you appeal Judge Green's decision on that motion?
I'm investigating because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct? I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again, don't interrupt me because I can go to 4 real quick. Judge Green, a judge in this court, ruled on that exact motion and denied your motion. That motion has not yet been appealed, and it certainly doesn't get appealed to me. Is that clear?
Yes.
Thank you. Next motion. Motion to
The judge can't just come in here and say that
yes, the judge can. Listen to me. Then appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion.
All she said was that Judge Martin was setting aside and that I should go sue the Secretary of State. The things that she's claiming and saying were never said to me. And anybody, I have all the recordings, they were submitted to the court. These things were never said to me. And then she comes here and makes these accusations and saying that the judge said this, judge said that.
Fine, then I'll say the same thing to you. Listen to me. Here, on your motion to dismiss for lack of jurisdiction, denied. By me, you can appeal me. Because the reason she stated, the Township of Huron issued you a citation. This court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay. Okay. Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. I really would. Because here's my dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant because that's my job as the gatekeeper after the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge, not because I don't like Mr. Crusoe. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision? Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling. That's not a legal objection. So that's 2 motions down. The next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside your defaults. All right. Do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside, defaults that were set aside are reinstated. Is that really what you want today?
Well, listen, the thing is,
Mr. Purcell, yes or no? You filed a motion asking me to set aside a decision that was made. Do you really want me to set that decision aside? Because that means those civil infractions are then in default and they're done. Is that a yes or no? Yes or no? Do you want me to set aside those do you want me to set aside the default set asides? Do you want me to reinstate those default judgments? Then I'll deny that motion. All right. You filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution? So am I. All right. The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
essentially, yeah.
Okay. Okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of non-consent. Oh, excuse me, motion for judicial notice. What does that judicial notice of what?
Certain terms that this prosecutor keeps trying to use and apply in this case that are not the lawful terminology being used.
Okay. For example.
You use motor vehicle.
Okay. Motor vehicles pretty much a term of art in our business.
Law of differences between how it's being used. Absolutely.
Well, then you can make those arguments, but you can't tell her she can't use that phrase. Yeah, but I'm not the trier of fact. So if you want to make an argument to the jury that her use of the term motor vehicle is improper, you can make that argument. Is that what you're concerned about? Is you're not going to be able to make the argument?
Yes.
Get what stuff on the record?
Filings.
Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions.
All of this has to go. Everything's taking place.
No.
Exactly.
No, that's not the way it works, Mr. Cazell. No, Mr. Cazell. All right, listen, brother, listen. You don't get to tell me what my job is. I've been doing it for 25 years. Listen. Well, then that's why they have appellate courts for the fourth or fifth time. I decide what this jury gets to see today. I decide. That is, by definition, the role of the judge at a jury trial. I get to decide what goes in front of that jury. If you don't like the decisions I make, you appeal those decisions. That's the way it works. What this